Rise, please. The Court of Appeals of Ohio, Second Appellate District is now in session with the Honorable Michael L. Tucker, the Honorable Michael T. Hall, and the Honorable Jeffrey M. Wellbaum presiding. All those having business before this honorable court draw near and you shall be heard. God save the United States, the great state of Ohio, and this honorable court.
Thank you. Please be seated. Okay, the case for oral argument today is David Esrati versus Dayton City Commission et al. And we have two appellees. How would you like to divide your time?
We've agreed that I'll take the first 12 minutes, Your Honor, and Mr. Garris will take the remaining 3 or whatever's left if I'm done sooner.
Okay. And I'll leave it to him to put the hook to you at the right time, okay?
Sounds good.
All right, thank you very much.
Thank you, Your Honor.
And Mr. Esrati, you have right to rebuttal. How much time would you like to reserve?
I'd like to reserve 3 minutes, Your Honor.
Okay, and I'll do my best to give you those 3. If you're in the middle of something, it may get strung out a little bit, but I'll do my best, okay? You may proceed.
Thank you. I'd also like to ask the court to give me 6 uninterrupted minutes to make my case, but I understand if you won't. May the court please the citizens of the great state of Ohio by protecting the Sunshine Laws, by remanding this case back to the Common Pleas Court for a full trial for adjudication on the actions of the school closing task force, a legitimate subcommittee of a public body is determined by the trial court for their multiple violations of ORC 121.22. I stand before you as a proverbial David versus Goliath and suggest the fundamental idea of proving what happens in a meeting that is closed from public view is impossible. To demonstrate, I ask that you consider a hypothetical scenario. As this is a public meeting, I would suggest you send the opposing counsel out in the hall, close the doors, as if we were engaged in what they call an information session, as they claim the task force was. When we're done doing whatever we're going to do, you can ask them to return to the room and make their case, and prove what happened while they were locked out of the public hearing, and prove that deliberations took place or not. I'm pretty sure they would protest, which proves my point. That was the essence of their defense and the judge's summary judgment. Since you obviously aren't falling for their information session excuse and sending them out the hall, there is a requirement to publish agendas and openly provide discussed documents on request. And since we're following the rules of Dayton Public Schools and the city used in this task force, I'd like to share some information with you. Mr. Wildermuth can tell you what it is in his presentation, okay? So you 3 have been informed of this as if we were on the bus with the doors locked, and you now know a fact that he does not. This is how he believes the city and the school board were allowed to operate. I'm sure you all got that by now because you're bright men and you can read. The basis of his ruling fails on several other grounds as well. The judge inserted himself in the process by ex parte requiring a TRO to be filed so he could act instead of the merits of my original brief, which clearly spelled out violations of the OMA and called for an injunction. His delay, in addition of the TRO and Rule 65 of the process, were unnecessary. So the layperson who is charged with the defense of the Sunshine Laws, comparing the definition of TRO versus the definition of injunction is splitting hairs, especially since the word injunction is stated 9 times in ORC 121.22. The word TRO, 0. So, our ORC 121.22 is very specific in outlining when a meeting can be closed to the public. The defense never claimed any of the stated exclusions were applicable. They claimed this was an information session, a term that does not appear in 121.22. In fact, the only place where it appears in the entire ORC involves operating or maintaining a solid waste facility. That's a nice way of saying it's a way to discuss the disposal of garbage. I have ideas on what the legal definition of information session should be per the OMA, but it's not really pertinent to this case, although it is a point of law that needs clarification. The case law that says some courts have allowed the term information session despite it not appearing in the ORC or the Sunshine Laws handbook, which is pretty thick, or any actual law does not make it law. Debates over whether deliberation has to take place in a meeting unobserved is twisted logic. Or the trial court's argument, that deliberation makes it an actual meeting, is a dangerous path that allows public bodies to close the doors more often than open them. Everything in the Sunshine Law Handbook says err to openness. This requirement is the opposite. Hopefully you are deliberating right now, yet there is no way for me to prove it. As to the banning of recording devices, another violation, and despite offers to audio record only and not to record at all, I was still banned. Each request was another violation of the law, and there were multiple attempts made. How do we know this? Because I was recording it, just as I am now. It's why we record meetings these days, to prevent irrefutable evidence of what happened, yet in this case was never allowed in court, although submitted as evidence. Mr. Wildermuth lied in his brief to the court. Further, as Rye's reference to alleged video footage showing he was denied access to the bus tour is not appropriate for this appeal, the evidence was never submitted in any form during the proceedings below. You can look in the docket. There it is. I have a copy here. The bus tour was 2.5 hours long, made 5 stops, and included people who are all supposed to know the Sunshine Laws and their correct application. It's a law so important that most of these people have had to attend training on it. I'm here to tell you that while these Goliaths of our city can pretend that an information session is somehow legal, I'm here as the proverbial David to tell you that the Goliaths have no clothes, and fear of their retribution may be enough for the newspapers and TV stations to back down, but not me. I swore an oath to the Constitution in this country. To me, this battle is critical to the protection of a free democracy. And if you don't overturn the trial court's action, you will have gutted the law, which is already poorly written and weak compared to similar laws in other states. To my knowledge, because of the way ORC 121.22 provides for removal from office, it rarely happens in Ohio, whereas in Florida it's fairly frequent. Unfortunately, in this case, despite multiple flagrant violations of the law and proven efforts to skirt it, these bad actors defy the law with impunity, with power to protect themselves with the taxpayers' money, and all you can do is remand it for fines and an injunction in my favor. Anything else and you'd be legislating from the bench. I've recorded this meeting because the people's business should be seen by the people. It's also why this hearing has a crowd and security, whereas most of your hearings do not. I hope you take into consideration when you render your decision. Open meetings of the law so people can observe and record. Anything less is not an open meeting. Thank you so much for letting me get through that.
Do you have anything else at this point?
I am open to your questions.
Do you have any questions?
I do have a question, Mr. Esrati. The case law seems to hold, including Helinski versus Lawrence, that deliberations and information gathering is not deliberations and not subject to the Sunshine Law. How do you respond to that, or how do you contrast that case?
Well, I'm not a lawyer, obviously, and I've read that case, but I'm not going to be able to cite it off the top of my head. But I can tell you this. The responsibility of closing schools in our community is one that is granted to one body and one body only. And that's the body that's publicly elected, the school board. They are the decision makers. And what they have done through this process is set up a proxy to do their, quote, information gathering and studying and consideration of the issue so that they can make a decision. Now, if we did this in every case of a public body, there would be no reason to have public bodies or public meetings because we could shield and hide every decision through the use of these subcommittees as proxies. That is not why this law requires people to take a class in it. This is why this law has a handbook. It's why it is so critical to the functioning of our democracy. There is no provision anywhere for anything about information sessions. And as to deliberations, I can tell you there are many public meetings and public bodies where no discussion takes place, but decisions are made. How do you define a deliberation? And how can we tell what was said or what wasn't said, or if there was an exchange of information if we're locked out of the room and not allowed to record it? And to say that they actually stopped their task force, which they did not. They continued on to the other schools. They just stayed in the bus and had a discussion. To say that that was not a matter of where they weren't discussing or making decisions about the future of our schools is as ludicrous Chris, as asking Mr. Wildermuth what I said on that sign. I'm sure he can't tell you right now what it said. We need this law to be enforced. If not, there's no, you just make a subcommittee. I believe, and I'm not a judge and I'm not a lawmaker, but the idea of an information session is so that members of a public body can go to a session on something like the Sunshine Laws and be there as a quorum and be given information on how these laws are supposed to be applied without having to call it a public meeting and have no minutes and everything else. I believe that is the purpose of an information session. I do not believe it is there for the discussion and debate over an issue that they have to decide upon. And again, real estate is one of the things you can make a provision for a closed meeting, for an executive session. However, this is, in Ohio law, you cannot do a real estate deal. You cannot sell a school building until 2 years after it's been closed, and it has to go through a special process. So this is not a critical meeting that has any executive session privileges, nor did they claim any of the stated provisions for executive session. So this fails on all counts. Again, you find it in ORC where information session is a legitimate excuse.
I'm referring to the case law. I'm not referring to the statutory language. I'm referring to the interpretation of it.
Okay. I am going to either have to go grab that case, or I'm going to say that you can go and look at so many other cases, like Thomas versus White, which says that a committee need not be a decision-making body in order to be a public body. And
That's a different issue. Whether it's a public body, the trial court determined in your favor.
Right. I didn't bring, I don't know if I brought Polanski. I cannot help you there. I'm sorry.
Thank
You
you.
can review the law. Thank you.
Do you have anything? I do not. You're welcome to continue your argument, or you can reserve the remaining of your time for rebuttal.
I'll take the remainder of my time. Thank you,
Yeah,
sir.
sounds good. You have 4 minutes.
Thank you.
Thank you.
May it please the court, I'm Brian Wildermuth here on behalf of the Dayton Board of Education with respect to this appeal. In the trial court, I also represented board member Mohammed Al-Hamdani. He was granted summary judgment, and that part of the trial court's decision has not been appealed. The way I understand Mr. Esrati's assignment of error, it is limited to the summary judgment ruling. He contends that the trial court erred in granting summary judgment. His contentions stem from his allegation that the OMA, the Open Meetings Act, was violated by a bus tour that happened on February 6th of 2018. Members of a right-sizing task force, members of the school administration, certain media members went to Valerie Elementary that morning. It was cut short, as you've seen in the briefing, but they did do a tour of Valerie that morning. Mr. Esrati testified almost a year ago on March 15th of 2018 that bus tour is the basis for his lawsuit, for what he seeks remedy. He is not entitled to the remedy he seeks, and the trial court properly entered summary judgment. The biggest reason is one Your Honor referred to in a question in the first part of this argument. The trial court determined that in order for the OMA to apply to the bus tour, there had to be evidence of deliberations. There was none. In fact, the only evidence in the record, the testimony from the March 15th hearing, was that there were no deliberations. Absent deliberations, the OMA does not apply. This court should affirm the trial court's summary judgment ruling. And the first and foremost reason for that is the lack of any evidence of deliberations in the trial court record. The trial court judge got it right. And he went out of his way, he bent over backwards to point out to Mr. Esrati that Mr. Esrati had the burden of proof, that it was his obligation to present evidence that there was deliberation at that bus tour if he hoped to overcome summary judgment. We had a phone call in which the judge made this clear to Mr. Esrati. Mr. Esrati said, no, I'm good with what I have. I don't need to do anything else. tools of discovery were available to him if he chose to take advantage of them. He did not. He did not produce any evidence of deliberations, and the only evidence was Dr. Lawley's testimony. She explained how they went to Valerie, they toured the facility. Mr. Rayford, the maintenance and facilities person for the district, walked them around. He showed them where there was some asbestos. He showed them some problems with pipe in the HVAC system. He talked about maintenance and repair issues and answered a few questions about those. There was no deliberation. The courts have defined what deliberations constitute. It's a weighing or consideration of pros and cons. The exact language, of course, is in the brief, but that's my paraphrasing of it. And none of that happened during the bus tour. The courts have been very clear. Pileski, Berner, Radke, others that are cited in the briefs that I'm sure you've already read. The law is not really up for debate on this point. Absent deliberations, the OMA does not apply. There were no deliberations in this case. This was purely an information gathering activity. Because there can be no proof of deliberations, the trial court got it right, and that decision should be affirmed.
How do you respond, Mr. Wilmuth, to Mr. Esrati's argument that you can't prove deliberations if it's a closed meeting when nobody was there?
Because the tools of discovery were available for him to get into that, Judge. Just as the trial court judge made clear to him, he had the opportunity, for example, to issue subpoenas and take depositions, could have questioned anyone who was present on that bus tour and asked them what happened. He did send out some what he called interrogatories to non-parties, which are not technically proper under the rules. He sent them to my clients, we responded. He sent them to some non-parties. I think one or two responded. That's all he did. I don't think he perhaps understood the tools of discovery that were available to him, even though the judge explained them to him. So that's how I would respond. Your Honor, his analogy about sending me out to the hallway is completely inapt. So I hope I've answered your question on that point.
Thank you.
Yes. So aside from the fact that there were no deliberations, and that is as far as you need to go here. Courts generally resolve cases on as narrow a basis as possible. I would suggest to you that that's what you do in this case. There's no reason to go further than the fact that the record contains no evidence of deliberations, the case is positive point, and you can stop right there. But if you choose not to, for whatever reason, the trial court got one point wrong. It found that this task force that Dr. Lawley created, not the Board of Education, not the Dayton City Commission, Superintendent Lawley created this task force. The trial court found it was a public body, but it was not. If you examine Dr. Lawley's testimony from the March 15, 2018 hearing, and if you look specifically at Exhibit D, that would be Board Exhibit D to that hearing, you will see what really transpired on February 20th, 2018 at that last meeting. The superintendent had framed some very broad questions. The members of the task force, who are local business folks for the most part, broke into small groups and they wrote down their thoughts in response to these broad questions. And you'll see what they said in response to Exhibit D. Mostly it's broad principles and values and goals, no specific recommendations. This was not a task force that made decisions. This was not a task force that reached consensus-based recommendations. And that's why the case that Mr. Esrati cited in his brief is readily distinguishable. What we have here is a school administrator, Dr. Lawley, who did what she always does when addressing something that commonly happens with school superintendents. And she testified about this. As an experienced superintendent, many times over the years, she has been asked or directed by her boss, the Board of Education, to provide it with a recommendation. And she has always had the leeway to explore whatever might be out there to inform her recommendation-making process. That might include...
Mr. Witherman, what in your mind would have made this body, this group, a public body under the statute?
Yeah, well, there are some cases we can look to. For example, there was one up in the northern part of the state, Greater Akron, I believe, where there was a statutorily created advisory board to advise a local children's services board. That might be enough, Judge, but here we didn't have anything like that. It would take a political subdivision like the Board of Education creating the task force And there would
But
have to
wasn't
be.
the superintendent acting on behalf of a publicly elected, Board of Education?
And there's case law like that, the Beacon Journal case, for example, and the other case cited, it's an Attorney General opinion cited in my brief, where the courts have held that an employee, which is what Dr. Lawley is, of a political subdivision, is free to information gather and set up groups to gather information from. Which,
But isn't she acting on behalf of the board as a superintendent?
well, I think that's fair, Judge. She's an employee
I
of
understand
the
she's
Board
an
of
employee.
Education. Yeah.
Obviously, she's paid by the board, but
Correct.
she is, working for and is, she's working for the board, and she's working on behalf of the board, and she was integral in the formation of this group. Fair enough?
She's like a chief executive, is how I would
Exactly.
analogize it.
Right.
So maybe it's akin, the Board of Education is like a board of directors of the corporation. They hired the chief executive.
Again, I understand that, but since she was working on behalf of the Board of Education, and she was integral in forming this group, are you saying that she could never form a group for this type of activity that would, that could be defined as a public body?
Boy, Judge, the word never is what gives me pause,
Well-
because I could compose of some
What if the
off-the-wall.
board, what if the board told her, we want this group, and she goes out and forms this group? Would that be enough?
It's not what happened here,
I understand,
Judge.
but if that is what happened, would that be enough?
I'm not sure. I hesitate to offer on a hypothetical that's really very different from what happened.
Well, all
here.
right, you have the superintendent, and then you also, as I understand it, had the mayor of the city of Dayton also involved in this, and these two folks came together, one being really in some ways the chief political officer of the city of Dayton, and the other one being the CEO of the Dayton School Board, coming together to form this committee. To me, that type of activity, giving rise then to a body to make recommendations, comes very close to being enough to have this organization defined as a public body under the statute.
The way the superintendent testified, Judge, she went to the mayor because the mayor was more familiar with business members who might be good to serve on the task force. So that is why she sought advice from the mayor. It's my understanding of what her testimony was.
Does that matter?
I think so. I
How?
think it
How
does.
does that matter?
The city wasn't involved in creating the task force. The superintendent created the task force to help her gather information and advise her recommendation-making process. But she's allowed to go to people who have expertise and knowledge that she doesn't have. And that's what she did here. Not only with the mayor, but with other folks to get their input. So I don't think you need to get there as a court. I think this case gets decided on the lack of any deliberations. But if you do, there was an error made by the trial court. The task force was not a public body, and that's another reason to affirm here. So those are the two big things that I wanted to address in my time. I'd be happy to answer any other questions, or I'll cede the rest of my time to Mr. Garris.
Anything else? All right, thank you.
Thanks very much.
Okay. Your 4 minutes.
Thank you. May it please the court, my name is Martin Garris. I'm an attorney for the city of Dayton. I'm representing the Dayton City Commission here. I concur with all the arguments that Mr. Wildermuth just previously stated. However, it is clear that the commission is not a proper party in this action. To violate the Open Meetings Act, a public body must hold a meeting within its public business. This is not within the public business of the city of Dayton. The public body's public business must relate to matters within its jurisdiction, control, supervision. Local school districts are separate and autonomous entities that are duly elected to govern the decisions of the school board and the school district. It controls the operations and maintenance of schools. The city of Dayton does not control the operations and maintenance of schools. Here, the task force conducted a fact-finding check to determine the operations and maintenance of the schools. These matters are exclusively in the power of, in the public business of the Dayton Board of Education and the Dayton Public Schools. It's not the city of Dayton's public business to determine whether or not school A or school B stays open. It's the public business of the city of Dayton to pick up trash, to operate the fire department, the police department, to pass tax levies. And as you can see from the record, there's no evidence to show that this was a task force that was created by the Dayton City Commission or reported to the Dayton City Commission. It merely was a task force that was giving advice to Dr. Lawley.
From what I can tell from the record, the city of Dayton's only involvement really was the mayor's involvement in setting up this committee.
That is correct. She was involved in giving recommendations.
But other than that, there was no other involvement that I can discern regarding the city of Dayton.
I believe that is correct. I think we had a commissioner who was on the task force himself, who was a
Committee member.
Yeah, he was a committee member, and previously he was a teacher, so he was involved with the operations of schools when he was a teacher. So he would have some expertise on it. But besides that, this is not the city's business. And although the city cares deeply about the success of Dayton Public Schools, as you can tell by our willingness to work with Dr. Lawley, it is not in our authority to determine or to tell or to recommend anything to the Board of Education, to Dr. Lawley, and it is wholly within our public business to discuss that. And with that, I will yield the rest of my time if you guys don't have any other questions.
No.
Nope. All right.
Thank you, sir.
Thank you. Thank you, Your Honor.
Thank you. You may proceed.
Okay, so you have a pro se litigant who makes mistakes in who we name and how we name them in the, captioning the filing, okay? Not to be, I should have named everybody on the task force, I admit that. Let's also say that Mr. Mims was the co-chair of this task force and ran the meetings and was not just a former teacher, he's a former school board member, a former state school board member, and a city commissioner. This man has had to at least take the sunshine laws 3 times, been required to take these courses and should know better. So, it's a good thing that we can also do public records requests because we saw communications from the mayor back and forth, and I had these documents between the mayor and Dr. Lawley and Muhammad al-Hamdani, who was not even yet elected to his position organizing this task force before he was in office. In fact, the first meeting where he tried to shut me down from videoing it, he was not yet, had not been sworn in to the school board. So, you asked about, what's going on here. Judge Skelton, when I turned in the brief on the 5th, said, oh, I can't act on this, because you only asked for an injunction. You need a temporary restraining order. So I had to go back and rewrite the thing and bring it to him the morning of the task force. And then he acted while they were en route. And al-Hamdani stopped the bus when he heard, got off the bus, because he didn't want to be involved, and Mims stayed outside of Valerie, yet rode the bus and was in the bus during some of the other meetings, or he left. I don't remember. But I had video of this. But in the 2 court hearings we had, Judge Skelton guided this to the discussion of whether we had to act on the restraining order, not on the violations of the actual initial brief. The initial filing said we want to talk about them having, communications about this, setting it up, how it was set up, refusing me from videoing the first meeting before the task force, about them refusing to give me an agenda, refusing to give me a time and date And we have those emails, and those were submitted in the docket. And how they even changed their language, and we have an email saying, don't send emails anymore about this because they can be requisitioned, do it on the phone. These are public officials, every one of them. The people on the task force were former county administrators, heads of Learn to Earn, an organization that gets tax dollars from us, the taxpayers, with no oversight. These are people who have been involved in our community for a long time. They all know better, and they all took part in this and did everything they could to skirt it. But they did allow the members of the media, the official media, on the bus, but didn't allow them to record, which is a violation of the Sunshine Law. And when I asked repeatedly, and I have this on video, which I submitted, which Judge Skelton says, we'll get to that at the next hearing, which we never had, because he threw it out based on how they guided these two initial meetings, which were just talking about whether the bus tour, whether he should have should have stopped it. And it was moot, he kept saying, because it already happened. That was not the basis of this case. The basis of this case has never been heard. The basis is they violated the Sunshine Laws over and over and over. And even said in the meeting after the task force had made the tour that they were holding this open because they felt it was a good idea, but they didn't have to. That's a violation. The ORC 121.22 says you violated just by threatening to close a meeting.
You're out of time, but you
Okay.
can summarize if you'd like.
To summarize, Judge Skelton didn't understand what the case was about. You had a rookie in there and allowed the defense to manipulate those two meetings to be focused purely on the one instance as opposed to the original brief, which has never had the case heard. And that's what we need to get back to try the original case on all the violations of the bus tour, of the task force, of the ORC. And then we can also include the parts about whether that meeting was illegal or not, and negates all the decisions made by this to close the school and to make changes in their headquarters, because that's what the outcome was. And technically, then we hope that the prosecutor or the attorney general steps in and removes public officials from office for knowingly violating this and taking extra efforts to violate it and spending an ungodly amount of money to defend themselves on these instances, because our government works for us. You work for us. And we want to have these things out in the open, in public, where everything can be seen, because sunshine is the ultimate disinfectant. And that's what needs to happen here. We need to have the case heard based on the merits in the original brief. And that's all I'm asking for. Just that chance.
Thank you very much. Thank you to both sides. We'll take the matter under advisement and issue a decision in due course. Thank you.
All rise.